Brown with I also have Jason Ross, probate and estate attorney with the Ross Group, and I also have Melanie and Lori with WFG National Title Insurance. And today we are here for a special educational workshop for real estate after life. While knowing some people like access to legal advice and institutions in regards to estate planning, we are on a mission to educate others and empower them to make the best estate planning decisions for themselves. Without proper planning, you will not be able to protect your assets from probate. Today, our expert speakers will explore the ins and out of real estate inheritance. So, whether you're a homeowner yourself, an heir of an estate, or just interested in the topic, this event is perfect for anyone looking to learn more about real estate afterlife. This will be an opportunity to gain insights and ask your wondering questions. And best of all, to make the most of your workshop, I will offer a complimentary consultation to everyone who attends. And the follow-up meeting is a great way to evaluate your options and discuss additional questions you may have after the workshop. So today you will learn what happens to real estate when the owner passes away. You will understand how a property is sold during the probate process, what a homeowner should do to avoid probate, some estate planning techniques such as a trust, will, and transfer on death, and also steps families can take before and after a loved one passes away. So to get started, I'm going to let Lori and Melanie take over their with title, and they're going to discuss a few documents needed to close escrow within title, and also some documents needed to close escrow if you go through the probate process. So, Melanie, I'll let you start, and or Lori.
Well, yeah, if I could open up, I'm the sales executive here at WFG Title in Richmond. I just wanted to say hello and just introduce myself and just let you know that for a couple minutes to let you know that I'm available here at our office or meet you anywhere to help you with any marketing ideas, farming, help you with labels. I can get you, get you that, and just share with you some ideas that maybe you've never thought of before in marketing your real estate business. I'm here for you. We are here for you, and so I just wanted to kind of interject that before I introduce Melanie. One thing that I do want to mention real quick, our company, WFG Title, we offer discounts, 25% off the owner's title policy. No other title company offers that, and we're really excited to share that. And besides the fact we're awesome. So I'll turn it over to Melanie Steely. She is one of my two escrow officers, and she's also our branch manager. So take it away, Melanie.
Hi, everyone. So Tashanik asked me to talk a little bit about documents that we would need to review if our seller has passed away and they hold title in a trust, or if it's an estate that's being probated. So if the owners held property in a trust and they've passed away, we do require a full copy of the trust to be reviewed. We're looking to see who the successor trustees are, and we're also looking to see if there are any specific directions in the trust as to whether the property that in question is being left to a particular party. Sometimes the trust will spell out that the property is going to be left to only one of the beneficiaries of the trust. So that's why we want to look at the whole trust. We can't just accept a certification of trust like we could if both of the original trustees are still alive. We also need to see the death certificates for the original trustees. And prior to close of escrow, we actually need certified copies of those death certificates so that we can prepare and record the affidavits of death of trustee. Sorry, there's a little background noise. I do recommend everyone that if you have a transaction, you have taken a listing or you're getting a listing, and the owners have passed away, that you order the preliminary report as soon as you get the listing so that we can check the vesting and make sure that the property is actually vested in the trust. A lot of times people set the trust up and they don't take the final step to actually do the deed into the trust. And that's a big problem, because if the property's not vested in the trust, we still are going to need a court order in order to proceed. They have to do a limited probate and get a Hegstat order in that case. And I have seen in the past, sometimes people have put the property into their trust and then refinanced it, and they were made to take it out of the trust for the loan, and it never got put back into the trust. So they think it's held in the trust, and it's not, because it was removed from the trust when they took their loan out. So it's just a good idea to go ahead and check the title as soon as you get a listing, so that we know if there are extra steps that are needed before you go into contract, because it can definitely delay your transaction. I actually have one now that's taken a year because the deed to the trust wasn't done correctly. The owner deeded it to his trust, but did not name a trustee in the vesting, and a trust is not capable of holding title. It's not an entity that's capable of holding title without the trustees named in the vesting. And he's tried twice. His father passed away, and he's tried twice to change that vesting. And we keep having to go back and say, that's not sufficient. You have to get a court order. You can't do that deed now. The original trustee would have had to be the original owner, to do that transfer. So we want to see the trust, and we want to see the death certificates. And those, you can always, once we get the order open, the preliminary report, we can get those reviewed for you right away. You can email those to us. We will need certified copies of those death certificates prior to close of escrow, but that's something that they can provide to us when they sign documents. We just want to let them know early that they need to get those, because a lot of times it's not just down the street for people when they have to go and get the certified copies. So that's for the trust is actually pretty easy. If you have, and we're only talking right now about after someone's passed away. If you also have someone who maybe the trustees are no longer capable of handling their own finances, they don't have the cognitive function to do that, then successor trustees can also step in that case. But normally the trust will define how that is addressed. And usually it's 2 doctor's letters just stating that the parties can no longer act as the trustees of their own trust. The trusts are definitely easier than the probates. If you have to go to probate, then you have to go through the whole process. It's a lot easier than it used to be, especially if you have a good attorney helping you, because they can do it under the Independent Administration of Estate Acts. They don't have to go necessarily to get a court order confirming the sale anymore. I still have had a few of those in the last few years where there was an order confirming sale required because there were some disputes between the heirs. And so the court confirmation was required for those transactions. But normally, if we have the Independent Administration of Estate Acts, and there's an attorney, we usually request the documents from the attorney. We ask for a certified copy of the letters of administration or letters testamentary, because we have to record those with our deed to show that that person had the proper authority to sign the deed on behalf of the estate. We also ask for copies of the notices of proposed action, which the attorneys prepare and send out once the contract is accepted. And that goes to all of the beneficiaries, letting them know that the property's being sold, how much it's being sold for, et cetera. Once the notice of proposed action goes out, the heirs can either sign consents to that transaction, or we can wait the 15-day waiting period to make sure that no one has objected to it, because they do have that time frame that they can object to the transaction. I've only had that happen a couple of times. And then it did have to go on to get an order confirming sale when one of the heirs objected. It seems to be that a lot of people think, the property is worth more than it is, and then they want to go and object to the transaction. We also asked for a letter from the executor or administrator or attorney just stating that there haven't been any objections at the end of the 15 days, along with addressing whether there's any inheritance taxes that will be due. And your customers do need to have a tax ID number. So, and this goes for the trust as well. They need a bank account either set up in the name of the trust or estate, whichever we're dealing with, and they need a tax ID number for that trust or estate so that we can report the sale under that tax ID number. So, again, it's a good idea to get the prelim as soon as you take your listing, so we can see too if there are any other issues that we have to deal with on that prelim. If there's a reverse mortgage, it's always a good idea for the administrator to be in contact with that lender to let them know that they are marketing the property, because they will start foreclosure process. You were supposed to sell it within 6 months of the death of the owner, or they will start the foreclosure process. So you want to make sure that that they're in contact with them and let them know that they're marketing the property, and sometimes they will, give them a little more time if that's necessary to do that. I think that's pretty much what as far as documents that we need to close, those are the items that our underwriting wants to review and make sure that we're dealing with the proper parties. And we definitely have a comfort level that we're trying to reach as far as risk involved. So we definitely prefer if there's a probate attorney that's helping the customers and they're not trying to do it on their own. I've done a couple where they did it on their own, but it's a bit of a struggle because they're not sure of all the guidelines that they need to follow. Anybody have any questions that I might be able to help with?
Let's see. Something. Okay, Jason just left his message in the chat. His info.
Sorry.
Okay. I don't think we have any questions yet. So if so, at the end we'll go over it. And if anybody have any questions, just be sure to input it inside of the chat.
And I'm available to, if anyone wants to reach out to me, outside of the meeting, if there's any specific questions that you have, please feel free to give me a call or email me. I'm happy to help.
Oh,
I'll put both of our phone numbers in the chat. How about that?
perfect. That's
And
working.
emails.
Yes, that's perfect, Lori, please.
Okay.
Thank you.
Okay. So now I'm going to give you some information about me. My name is Tashnik Brown, a California licensed real estate agent, proudly serving the Bay Area and surrounding cities. Being a dedicated realtist with Cotton Realty, I provide effective marketing strategies, professionalism, and personalized services to every client interaction. Excuse me. So whether you're a first-time home buyer, a seasoned investor, or a seller of a property, I specialize in guiding you through every step of your real estate journey. As a certified probate and trust specialist, I bring added value, expertise, and provide empathy to families and individuals navigating the complexities of probate and trust transactions efficiently. I am passionate about educating my clients and ensuring they understand every step of the probate process by communicating the legal concepts in a clear and understandable way. In addition to my real estate career, I am a proud member of the National Association of Real Estate Brokers, a historic nonprofit organization committed to democracy and housing. As a realist, uphold NARAB's mission to promote fair housing and economic opportunity, especially within underserved communities. This commitment to the community empowerment and advocacy is at the core of everything I do. Real estate is more than just a transaction, it's a major milestone. I'm committed to being your trusted partner in real estate and making the process seamless, informed, and empowering every step of the way for every client that I serve. So, overall, I am here to provide trusted guidance, education, and dedicated support, which brings us here today. And okay, so we're going to go into
I
what.
keep that strap on me. Hot water, I pull that trigger.
I'm so
Fuck
sorry,
with
man.
that real nigga.
Gosh, thank you. So, what happens to real estate when the owner passes away? What happens is the heir will come to me and they will say, hey, I want to sell this property. My family member passed away. So the first thing I will do is I will pull the title of the property. And the title is going to be in either two names. It's going to be inside of a trust or it's going to still be in the deceased owner's name. So if it's in a trust, as Melanie explained earlier, it's pretty simple. We'll get the trust documents and see who is the successor trustee. They're the person who signs the listing agreement with me so that we can list the house for sale. Um, Once the house closes and close escrow, the house sells and the money goes into the trust account, and then the funds are dispersed based on the instructions of the trust. Now, if the property is in a deceased owner's name, the first step we will have to do is contact the probate attorney, Jason, or your preferred attorney, and to get the probate process started. And then what will happen is the court will issue some orders and letters. It's going to be a document issued by the court, which would then grant an administrator or an executor. It'll be administrator if there was a will in place, an executor. I'm sorry, an executor if there's a will in place, an administrator if there's not a will. And they will be the person that signs the listing agreement. But I cannot sign a listing agreement to list the property for sale until we have that documentation. And it is, like I said, it's a process that you have to go through, and I'll get into that a little bit later. After we sign the listing agreement, we'll list the house for sale. We close escrow and the house sells. After that, though, the heirs do not get the money. What will happen is you'll have to go back to court for a hearing for distribution, and then at that time, the judge will grant the money and let you know when you can have it. So if your house is not in a trust, pretty much your heirs won't get the money right away after the house sells. It'll still be a waiting process. And some people wants to know what is probate. Probate is the legal process through which a deceased person will is validated and their assets are distributed according to their wishes or laws of intestacy if no will was created. It involves proving the authenticity of the will and settling any outstanding debts and taxes and transferring the remaining property to the beneficiaries or heirs. Intestacy in California is if someone dies without a will, their assets are distributed according to a set of order of priority, typically favoring close relatives like spouses, children, parents, and siblings. The state ensures that their assets are distributed and that any children under 18 without a living parent has a caretaker for their funds. So this is just a bit of order and test to see if you have a surviving spouse. And that gets tricky also because some spouses think all of the property goes to them, but it don't if it has to go through probate. And so then it'll be left to children and grandchildren. So this is and down on to cousins. So this is just a list of kind of how the court will go in order to distribute the funds. And so, for example, if you had no living children that were passed away, then it will go down to the grandchildren and then so forth. So next, we're going to get into the home selling process and probate. This is just kind of a quick timeline. It does depend on the county and court soonest calendar date availability and also the complexity of the case. So like I said in the beginning, you will contact me. I'll let you know, hey, the property is still in the deceased owner's name. And so you will gather a few documents, such as a will, if there is one, a list and contact information of all family members, and a death certificate is a few documents that you will need to provide to the attorney. And so then you would, once you reach out to the attorney, that is pretty much when the process starts, when they actually file a petition in court, and there will be some upfront filing fees. The next step will be, which is sometimes 3 months down the line from when the attorney first initially filed the petition. And like I said, the timing can change based on the court's availability. But usually, sometimes within 3 months, the letters in order is issued by the administrator, and then the administrator or executor would obtain a bond. And then at that point, the real estate transaction can start. I can sign a listing agreement. We'll accept the offer, open escrow. Um, as Melanie said, you will open an estate bank account with the EIN number. This will be at the help of your attorney, so they'll help you along the way with some of those steps. And then we'll close escrow. So once the house is sold, the attorney would usually send a notice to creditors and prepare for final accounting. And then they will file a petition for final distribution in court to have the funds distributed. And then there will be a court hearing, and then you'll receive a receipt for distribution from the judge and get a petition for discharge, and then the case is closed. And that document you would take to the bank, and at that time, the funds could be dispersed. So, um, if you're selling a home within the probate process, it's very lengthy. It can go past 12 months. I've sold some properties where the heirs have not gotten their funds to at least 18 months over. So sometimes it's a very lengthy process. So this is just a quick document about full authority or limited authority. I'm not going to go deep into this, but a little bit of what Melanie was saying. Full authority is a much simpler probate process. And you can talk to your attorney about this versus limited authority. Limited authority, you go through a court hearing and a bid and have to petition for confirmation, and it's a little bit more in depth. And so the best that you'll ask your attorney is to get you full authority when you're going to probate court. It much makes the probate process much simpler. And so, how to avoid probate? How you can avoid probate, you would establish the best and number one way is to establish a living trust. And I'm going to pass it on to Jason in a moment, and he'll get into that on how to properly set up your living trust. Also, you can file a head stat petition, and that is just if, as Melanie was speaking, if you put your property inside of a trust and then you pull it out to refinance, and for whatever reason you happen to pass away before you put it back inside of the trust, you can file for a head stat petition, showing that the property was in the trust, where your heirs can file this head stat petition and showing that, hey, the property was in a trust, but they took it out at refinancing and didn't get a chance to put it back. And that is a way to avoid probate. It's not as a simple process as trust, but you don't have to go through the lengthy process of probate. Also, you can avoid probate by a revocable transfer on deed, death deed, which is usually known as a TOD. That is something that you file with the courts. I don't really recommend that because it's when we get to title, it's very tricky, and it's again not as simple as living trust, but it is a way to avoid the entire probate process. And then also another way to avoid probate, which this is a new law that went into effect this year in April 1st of 2025, is a succession to primary residence petition, and it's Form DE 310. And so what that is starting if on April 1st and going forward, if someone passes away and the property is their primary residence, their heirs can file this petition if the property is value is less than 750,000. Now, prior to April 1st, the value I believe was about 187,000, if I'm not mistaken. And so here in California, it's not much property that value is under 187,000. So pretty much all properties was having to go through the probate process. And Gavin Newsom, he signed this into effect to kind of ease up the probate court because they're very overwhelmed with a lot of probate court transactions. And so this is the way how they ease it up. I'm not sure on how it's going to go because, like I said, it just started April 1st. And then also you can't file the petition until after the owner has been passed away for 40 days. And the another thing is you also have to file this petition, and you can possibly still go through probate if all of the heirs cannot come to an agreement. But it's just something to know if you have a family member that passed away and the property value was under 750,000. This is something that you can possibly file a petition for and avoid probate. So selling a home and timeline in a trust is very pretty much simple. You will meet with me for a consultation. You will gather your documents such as the trust binder and death certificate. And then the trustee will sign the listing agreement. We'll prep the home for sale, accept the offer, and close escrow. The money goes into a trust account, and then the funds are dispersed according to a trust. And this can take up to 2 months or timeline depending on the market and how fast to sell home. So selling a property in a trust, you pretty much don't have to deal with anything within the court. So that is why I recommend anyone, if you have a property, the best way to protect your assets is to put it inside of a trust. And some people might not know what a trust is. And so a trust is a legal entity that allows property to be passed from a person who created the trust, who was the grantor, to who they want to inherit their property, the beneficiary. And the trustee oversees the trust and manages the assets on the trust's behalf of the beneficiary and according to the grantor's instructions, which this is the best way to avoid probate. So overall, the benefits of estate planning, you control distribution. You can specify who receive your assets and in what portions. You control and ensure that your loved ones are cared for according to your personal wishes, rather than leaving your decisions to the state and the court. Again, you avoid probate in the whole court process. You also protect your assets because with proper planning, you ensure that they are distributed to your wishes again. And the protection is very crucial when you want to preserve your wealth and maintain family harmony. You also have a peace of mind, knowing that your estate is order. It provides a peace of mind for you and your loved ones. And it also elevates the burden on their family members who might, otherwise be facing difficulties during an emotional time. And also the benefits of estate planning inside of a trust, you can have a healthcare directive. So, such as the living will and power of attorney. So you can ensure that your medical decisions align with your personal values before you get sick. That is also something that's done in your estate planning. So there are a lot of benefits of estate planning. This is just to highlight the importance of estate planning and to avoid probate and delays in distributing your assets. These are some celebrities that have passed away with no will or trust. Quavo, Prince, Amy Winehouse, Barry White, Aretha Franklin, and Chadwick Boseman. Those are a few to name, and it's a very lengthy process. Chadwick Boseman, I know offhand, he had to pay his estate was worth about $4 million, and he had to pay 1.5 million in the attorney and court fees. So that was some money that could have went to his family. And then it also took some time for them to get their funds. So you want to take this as a learning lesson. To avoid that. Also, this here is some properties that I have sold via probate, to show you that it is real. Families do have to go through the situation. I've sold a property in Oakland, San Pablo, and two properties in Richmond that went through probate. And if you look at the screen, you'll just see a little bit of the information. One of them, the petition was filed in March of 2023 with the attorneys. In this particular transaction went a little long because the owner passed away, who was a married woman, and then her husband also passed away. So there were two estates on the property, and so it took a pretty long time before we can sell it. But once we sold it in May of 2024, it's been going through a lengthy distribution kind of argument and disagreement in court. So right now they're settled to go back to court next month. Hopefully they can get their funds, but this estate, the money is just sitting in the account. The house has been sold. And so putting your property in a trust, that is something that you can avoid. Um, and so some steps that you can take before and after death, I recommend, is to have open and transparent communication about your intention and plans on how you want your property to be dispersed. Also, you want to identify someone who can take care of business when you're selecting your trustee or your administrator. You want to select someone that you think in hopes that can, handle business when it's time to, and also dealing with your passing. And also you will want to decide on how you would like to distribute your assets. I know sometimes this can kind of get hard, but it's something that you really want to do because you don't want to leave it up to the courts. And then you also want to properly set up a living trust. And then another step you can do is always contact myself or Jason for guidance on what to do next. And so now I'm going to pass it over to Jason. And he's going to go over some information on kind of how to properly structure your living trust, some estimated costs, a few documents needed for probate and upfront fees, and the best way to contact him for services.
And
So, Jason,
Dashanique, I'm
yes,
so sorry to jump in here, but is it okay if Melanie and I bow out? And I left our information in the chat if anybody
perfect.
wants. Okay, thank you so much for the invite. Really, really appreciate it.
Appreciate you for
Let us,
hopping on.
thank you. Let us know. You
No
can take a
problem.
picture or however you want to get our information, but thank you so, so much. Let us know how we can help. Okay.
And this is recorded, so you guys can always check it out on the YouTube
Okay.
channel.
Okay. Thank you.
Okay,
All
thank
right.
you, Lori.
Take care. Thanks.
You
Bye-bye.
too. Okay. Okay, Jason, are you there?
Awesomeness. Thank you.
Okay, no problem. Thank you. You want to do a quick introduction to yourself?
Yeah, I feel like my work is done. Your presentation was so good. I don't really need to do too much.
Thank you. Well, I need them to hear from the professional. I'm not an attorney,
I
so
love it. I love it.
I want, to get some insight from you. So
Absolutely. Jason Ross with the Knox and Ross Law Group, originally from Los Angeles, came up here to go to school, went to UC Berkeley for undergrad, University of San Francisco for law school. Been a member of the state bar since 2012. A member of the National Bar Association, as well as a board member for the California Association of Black Lawyers, member of Kappa Alpha Psi Fraternity Incorporated, as well as a member of a motorcycle club. So I ride motorcycles with the Kings of Cali for my fun time. So that's just a little bit about me. And the reason that we're here is really about money. We're trying to protect, build, and protect wealth. At the end of the day, we work hard, we invest, and we want to make sure we protect our assets. And so what we're doing is putting together a roadmap that allows you to protect your assets. And what I have been doing with NARAB, the National Real Estate Association, as well as with the National Bar Association, we do a what to do with Big Mama's house presentation. Because in so many of our communities, we're familiar with a house, a home, a family home, and many times that family home is lost after someone's death in the family. And so what we want to do is figure out ways that we can protect those homes and protect that wealth that's associated with those homes. So what we talked about is how to avoid probate. And one of the biggest ways to avoiding probate is having an estate plan. And what's consisted in an estate plan? We have wills, trusts, power of attorneys, advanced medical health care directives, are four documents that are essential to an estate plan. Now, what is a will? A will is a set of instructions that allows you to distribute your assets the way you want to distribute those assets. A trust is also a set of instructions that allows you to distribute your assets the way you want to do that, the way you want to do so. Now, why would you have a will and a trust in your estate plan? The reason is a will, when a person passes with a will, it goes through probate. The only difference with passing with a will versus not passing with a will or not having a will is when it goes through probate, the courts use the will as your set of instructions. So a will does not prevent you from going to probate. It does not avoid probate. Now, when someone passes without a will, then the courts use the laws of intestacy that have been described in Tasha Ms. Brown's presentation to figure out how the succession should be. Now, what happens when you have, if a person has somebody in their succession that they don't really want to inherit? Well, if you don't have instructions for that, then those people may be in line to inherit. So with a trust avoids probate. A trust is and what we call it is a revocable living trust. And what that means is the trust is modifiable, changeable while you're alive. When a person transitions, that's when the trust becomes non-changeable, non-modifiable. So the way a will and a trust work in an estate plan, we use what they call a pour-over will. And the way I describe a pour-over will is a pour-over will basically gifts your entire estate to your trust. Now, you may be asking, why would I do that? Well, we call it a pour-over or catch-all because it's gifting to the trust because the trust is modifiable, changeable while a person is alive. And so as a person may have created a trust, they may still be acquiring assets. So as they're acquiring assets, sometimes they get to transfer those assets into the trust during their lifetimes, and sometimes their transition happens before those assets are able to be transferred into the trust. So the will gift your entire estate to the trust, so that if anything was not been, you weren't able to get it into the trust, it is gifted to the trust. So it kind of catches all in the event to avoid probate. So a trust is a set of instructions. It's almost like, I look at it as a kind of like a shell company that you manage. So you're putting your real estate transactions into the trust. And so now the trust owns the property, not you as an individual. And so that allows for you to be able to direct how you want that asset to be distributed. Now, one of the key points that was talked about is vesting. One of the things is when a person creates a trust, their real estate doesn't automatically go into the trust. You have to do what we call a trust transfer deed. And that trust transfer deed properly transfers the real estate, and it makes the trust the owner. But you are the trustee of the trust, meaning you're kind of like the CEO of the trust, so that you're still able to manage and own and operate your assets as though they were outside of the trust. But the trust gives you protection for when a person transitions. So again, we have a will as a set of instructions. We have the trust as a set of instructions. The will and the trust both work hand in hand. The trust is the device that avoids probate. Now, when we're moving through the estate planning process, one of the things that we always want to make sure we do is look at our beneficiary designation forms as well as our pay on death accounts. Why is that? Some of us have had the opportunity to be married one time, 2 times, 3 times, whichever a person may be on. But many times I get phone calls where someone will have transitioned, passed away, and they would have been on their 2nd or 3rd marriage, and did not make any changes to their insurance, to their 401ks, to any of their accounts that they were the sole owner on. And those those institutions or those financial investments are contracts with that person and that particular company. So whoever is on the beneficiary designation form, even if a person has a trust, if the trust isn't named, the person who's listed on the beneficiary form is who that money will go to. So it's very important to make, when life changes happens, to update your beneficiary designation forms, to update your pay on death forms, because those are very crucial documents that dictate who gets distributions. Power of attorney and advanced medical health care directives. Those are two documents in the estate plan that I say help people while they are alive. Power of attorney allows you to select or appoint a financial advocate, someone to take care of your financials if there was anything that were to happen. Why is that important? I get phone calls from married couples, and something happens to one of the spouses. And in many situations, there's 3 bank accounts. There's one for the husband, one for the wife, and then there's a joint bank account that they both use to help with the bills. But they're still dependent on each other's account to go to the joint account, to make a contribution to the joint account. So if something happens to one of the spouses, just because you're married doesn't mean that you will have access to that other person's banking or financials. So it is very important that you select a financial appoint somebody to take as a financial representative to take care of your financials when something is preventing you from doing so unexpectedly. So power of attorneys, again, allow you to appoint a financial representative to take care of your financial business if something were to happen to you. Advanced medical health care directive. Why is that important? That's important because that's where you are allowed to select a healthcare advocate to take care of any healthcare decisions in the event that you're unable to make those decisions. So again, power of attorney, advanced medical health care directives, 2 very important documents that help you while you're alive. So the whole goal that we're talked about today is making sure that we're protecting our assets, protecting this generational wealth so that we can build as a community. And as the the title representatives were explaining, and as Ms. Brown was explaining, the probate process can be a very lengthy process. There's many documents that have to be filled out. They have to be filled out correctly. If you make one error, it can send the whole process and start it over. Part of the challenge with probate is sometimes there's so many cases being initiated that the dates in order to start a probate are pushed out 30 to 60 days. And sometimes you get situations where you weren't realizing, but before somebody passed, they were behind on their mortgage. So sometimes the properties are facing foreclosure. And so now you're in a situation where you're trying to get into the probate court, you're delayed getting into probate court, and the house is in jeopardy of foreclosing. So you don't, if at all possible, you don't want to have your family go through the probate process to protect the wealth that you've spent so much time building that you want them to benefit from a generational perspective. So again, we want to make sure that we're avoiding probate so that we can continue building wealth and protecting our generational wealth. Any questions?
Okay, let me see here if we have any questions. Someone asks, can one contest the will on items not in a trust? Someone asked.
So not really clear on that question, but usually you have if there's a will being contested and there's a trust, we would have to
I'm
look.
sorry, I'm sorry, I'm gonna interject. It was a question because we're streaming live on Facebook. So someone is asking, can you contest the will if there are no items for items that are not in the trust? So you have something that's not in the trust, but it was in the will, can it be contested?
the way okay, one of the things that I didn't do, I want to make sure that I do my disclaimer. Everything that I'm giving is opinion. I am not creating an attorney-client relationship. Everything is per opinion. So I just want to make sure that I'm clear. But once you call me and contact me and we engage, we can definitely establish a client-attorney relationship. But people ask about will contests, trust contests. Anything can be contested. So but that doesn't necessarily mean that they're going to win on the contest. So it really depends on the scenario. So I would have to really have more information. But to simply answer the question, anything can be contested. It's just not sure that that will or trust contest will be overcome based on the facts.
Okay. Jason, I have a question for one of my clients. They had asked if they're a married couple and they place their property in a trust and one of the spouses passes away, can the other spouse then go in the trust and make changes to what they already had in place?
So first of all, I would have to review that particular document.
Okay.
Answer that from a general perspective. Usually, when married people have a joint trust, when one of the spouses transition, then that remaining spouse is now the trustee, and they have what they call a survivor's trust that's outlined in the trust that they can continue managing the property in the trust.
Okay, but they can't make any changes, like say they want to add someone or take someone out of
So
it, if that makes sense.
So usually the simple answer is usually the ways the trusts are set up is whatever distributions have been decided while both persons are alive will need to be honored in the trust.
Okay, gotcha. So if one person died, they can't kind of pretty much can't go and change it. Okay.
Well, they can't change what they've decided on, but when they can add to the trust. So if they're
Okay.
adding to the trust, so it's a very specific question. So I wanted to make sure
Okay.
there's different scenarios that relate to
Gotcha.
that.
So I'll just have her reach out to kind of explain her scenario and kind of her specific questions. Did anyone else have any questions you want to type in the chat or take your phone off of mute and ask? Okay, well, I'm going to leave my phone number in the
Well,
chat.
Puda,
Yes.
hey Puda, this is me, Tanya Lewis. I will talk with you and ask some questions offline because I originally didn't think that this Zoom would be for me. I thought it would kind of fit my friend that's kind of becoming a new realtor, that it can be some knowledge for her. But
Okay.
actually, I'm a homeowner, right? And I have a son that's about to be 25, and I did think about getting I think it's a living trust and all the things that you guys talked about. I'm at work right now and I really couldn't listen in, but I heard it was recorded. I'm gonna replay it, and then that's something that I definitely was wanting to look into.
Yes, yes. And you can
Before we
always
wait till it's
reach
too late.
out to me whenever
I will
contact
definitely.
me. And yeah, we can go over your specific situation.
Okay, and then I have a friend that she's in probate with some stuff because she was a the power of attorney for someone that was ill, and she may have some questions, but we'll chat.
Okay,
I'll
definitely.
talk with you offline. Nice meeting everybody. Appreciate you two brother doing your thing as a lawyer. That's very very motivating to hear your story, and we appreciate your time for being on with us. Thank you so much. I'm gonna mute myself now.
All right. Thank you, Tanya, for joining.
Thank you so much. And I
You're
think
welcome.
one of the things that I try to make sure I address is
Oh,
usually the cost of establishing a full estate plan can range, from 2,500 on,
somebody, Tanya, mute yourself. Or can I mute you? Okay, there it is.
just depending on the complexities. But what I try to do is make sure that we're tailoring the price to meet the needs of the family. And for everybody who is on this call, I just want to make sure that you understand that there will be a $500 credit. So just mention that you were on this call and that you'll receive 500 off of your estate plan by the gift of Miss Brown for inviting all of you guys here.
Thank you, Jason. Thank you. I'm sure that will help someone and get them to really plan their estate because it's so important. I just recently did a Juneteenth event And literally about maybe out of 18 people that stopped at my booth, one person in that own property, one person had their property in a trust. So it's so important. I'm just glad I can bring you guys this information. I hope you guys thought it was helpful. And again, you can reach out to me anytime. I'm always available to hear your situation and see what can we do moving forward. And then also, if you're looking to purchase a property or sell a property, you can also reach out to me as well. Okay, if we don't have any more questions, we kind of got to squeeze everything in 53 minutes. So we got about 7 minutes left. If anybody wanted to ask anything, ask one more time. If not, yeah, we'll end this Zoom. And thank you all for joining again. And nice to meet you all and talk to you soon.
All right. Thanks
And
a lot.
I just want to say I'll follow up with everyone that joined and see if you want to schedule a consultation in regards to your specific situation as well. So I'll be in contact with you all.
Perfect.
Okay. Bye-bye.
Thank you.